Well, hopefully she wasn't sitting there. Well, we're trying to. Mine says I'm still thinking about it. Okay. Got it. Okay, now the live stream is set up. Court will call cause number CR 19-225, the state of Texas versus Carla Maynard. For purposes of an agreed plea, what say the parties?
Case ready.
Defense is ready.
Ms. Maynard, can you please unmute that computer? There we go. First document we need to go through is the joint request for plea or sentencing by video conference, which purports to have all the parties' signatures. Is that correct?
Yes, Your Honor.
Yes, sir.
Ms. Maynard, do you have any objection to proceeding by video conference?
No, sir.
Thank you. Next document we need to go through is the 3914 Discovery Disclosure and Compliance Form, which purports to have each of your signatures. Is that correct?
Yes, Your Honor.
It does.
To the best of your knowledge, has the state received all discovery from law enforcement and forwarded the same to the defense?
Yes, sir.
To the best of your knowledge, have you received all discovery?
Yes, sir.
Ms. Maynard, I'm showing you a document entitled Defendant's Plea of Guilty, Waivers, and Admonishment. Did you have a chance to go through this document with your attorney?
Yes, sir.
Did you understand this document?
Yes, sir.
Do you understand that you have a right to a trial by jury?
Yes, sir.
Do you understand that you have a right for your attorney to cross-examine the state's witnesses and to call your own witnesses?
Yes, sir.
And do you understand you have a right to appeal?
Yes, sir.
Do you understand that you're waiving all three of those rights today?
Yes, sir.
In addition to that, do you understand that you have a right to remain silent? Nobody can require you to testify against yourself, but you can in fact waive that right.
Yes, sir.
Page 3 of this document purports to have your signature in 2 different locations. Is that your signature in both spots?
Yes, sir.
Your second signature appears below a paragraph entitled Judicial Confessions and Stipulations. Do you understand that by signing that paragraph, it's just like you stood up here before the court, raised your hand and said, I did what the state's accused me of doing?
Yes, sir.
Attached to the back of this document is a copy of the grand jury indictment. It purports to have your signature.
Yes, sir.
And are you asking the court to accept as true and correct this grand jury indictment?
Yes, sir.
Do you feel like your client understands her rights, waivers, and admonishments?
I do. Yes, sir.
Ms. Maynard, you've been charged with theft of property between $30,000 and $150,000. This is a third-degree felony with a range of punishment of 2 to 10 years incarceration and up to a $10,000 fine. Do you understand this charge and this range of punishment?
Yes, sir.
And how do you believe?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, sir.
Are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
And are you a citizen of the United States?
Yes, sir.
Do you feel like your client's competent and capable of assisting you in preparation for trial?
Yes, Your Honor.
Is there a plea agreement?
Yes, Your Honor. State's recommending 3 years deferred adjudication, a $1,500 fine, drug and alcohol treatment approved by the probation department, completion of life skills class, and restitution in the amount of $4,000. And with that, cause number CR 21155, we're filing a motion to dismiss.
Is that your understanding, Mr. Winsky?
Yes, Your Honor.
Is that your understanding, Ms. Maynard?
Yes, sir.
All right, let's talk about deferred adjudication for just a moment. You understand that deferred adjudication is like a two-sided coin. If you successfully complete all the terms and conditions of probation, not only do you not have a final conviction, but you may be entitled to file a motion for non-disclosure.
Yes, sir.
Okay. Do you understand the flip side of the coin? If you violate the terms and conditions of probation, not only do you not have a final conviction, but you may be entitled to file a motion for non-disclosure.
Yes, sir.
Did I do that? Sorry, I got distracted. Hang on real quick. Do me a favor. Go to the law library and tell the attorney in the law library to either turn his video off or quit bouncing around. One of the two. Okay. The flip side of the coin, Ms. Maynard, and I apologize, is that if you violate your terms and conditions of probation, you're subject to the full range of punishment for the offense. You understand?
Yes, sir.
Do you also understand that a plea agreement is an agreement between you and the state? It's not binding on the court, but if the court did not accept your plea agreement, you would have the opportunity to withdraw your plea of guilty, enter a plea of not guilty, and proceed to trial.
Yes, sir.
And are you asking the court to follow the plea agreement?
Yes, sir.
Court will find evidence beyond a reasonable doubt to enter a finding of guilt. Pursuant to your plea agreement, will defer any such finding of guilt for a period of 3 years. You have a fine in the amount of $1,500. You must successfully complete the drug and alcohol treatment program if ordered to do so by probation. You must successfully complete the life skills program. You have restitution in the amount of $4,000. You have court cost in the amount of $290. And you have reimbursement fees in the amount of $600. Do you have any questions on the judgment itself?
No, sir.
Once you get released, can you work out a payment plan to pay off your cost?
Yes, sir.
Thank you. Now, attached to the back of this document is an order granting community supervision. Did you have a chance to go through this order with your attorney?
Yes, sir. I did.
Did you understand this order?
Yes, sir.
Do you understand this order contains all your terms and conditions of probation?
Yes, sir.
Do you understand your terms and conditions of probation include a $60 per month probation fee?
Yes, sir.
One-time $50 Crime Stopper fee that's due within 6 months?
Yes, sir.
Do you understand you're subject to random urinalysis and drug tests at your own expense?
Yes, sir.
Do you understand you're agreeing to a search of your person, your place, your residence, your vehicle, or any electronics to ensure conformance with the terms and conditions of probation?
Yes, sir.
Do you understand you must successfully complete the life skills program?
Yes, sir.
And do you understand that if ordered by probation, you must successfully complete a drug and alcohol treatment program?
Yes, sir.
Where do you work?
I have a business
What kind of
for
business?
construction cleanup.
You stay pretty busy,
Not now,
right?
but I'm sure I will as soon as I get out.
All right. As a term and condition of probation, you're going to have to complete 125 hours of community service. Work with the probation department to work around your job requirements, okay?
Okay. Yes, sir.
You have any questions?
No, sir.
Good luck to you, Ms. Maynard. Thank you.
Judge, if I may.
Hey,
Ms. Maynard, if you would report to the Bandera County Adult Probation Department. It's right there in the same building as the jail
Okay.
whenever you get out, okay?
Okay.
Okay,
All
thank
right.
you.
Thank you.
Thank you, Judge.
Thank you.
you're welcome.
Your Honor, that's all I have on the docket. May I be excused?
You may. Thank you.
Yes, sir. Thank you.
What's the date on?
6/28, I think on this one.
Is that the person that's in front of the screen in the jail?
No.
Okay,
That's,
then let's deal with this in a minute.
that's her behavior.
Hey, Ms. Barnett?
Yes, thank you.
Ms. Barnett, can you hear me? Okay, your attorney is going to pass your hearing today so that he can talk to Mr. Winsky because you have multiple attorneys representing you on your cases, and he wants to make sure y'all are both on the same page, okay? So we're not going to actually do anything with your case today. Okay.
Yes. Yes. Thank you, sir.
Thank you. Okay. So Durbage, is that how you pronounce that? Durbage. So I've got one dated June 7th to the eyes,
And then again,
28.
where I guess you went ahead and uploaded it, or the PDO.
Yeah, I think that's why I did that too. When I remember. This is a bond hearing?
Yes.
Okay. Court will call cause number B 21-295 and 21-449.
Good morning, Your Honor. This is Miguel on behalf of Mr. Durbage. I'm sorry about
Yeah,
earlier being all over the place.
unfortunately, this is not Mr. Durbage in the chair though. You're Mr.
Oh, I'm sorry.
Overgaard, correct?
Yes, sir. Mr. Overgaard is my name.
Okay, your attorney is in the middle of a jury trial next door.
Yes,
So
sir.
he's not gonna be able to be here today. So we'll get you back up before the court as quick as we can, okay?
Yes, sir.
Thank you.
Yes, sir. Thank you, Judge.
Can you hear me in the Kerr County Jail?
Yes, sir. You need Durbage?
Durbage is next, but if you have your docket in front of you, we do not need Crawford, Gustafson, Stacy.
Okay, so Durbage should be the last one?
Correct.
Yes, sir. 28 to 30.
Well, as soon as I looked, I would have noticed, but yeah, they're all different. Overgaard's a different person. Durbage at motions hearings. Counsel, are these motions for bond reduction?
Your Honor, there are motions for personal reconnaissance bonds or in the alternative bond reductions. Ms. McCollum had filed them. I'm filling in for her since she's at the trial college for the week.
And it's on both cases, is that correct?
That is correct, Your Honor. And I'm sorry about earlier being all over the place. I was texting my witness, which since I'm doing Zoom on my phone, that's why I was in and out. It won't happen again.
It looks like 21-449, we need to get him arraigned too.
Okay, I can arraign him.
Yeah.
So as far as
Well,
the arraign,
hang on real quick. Before we even call it for that, I'm assuming you've not met with him and gone through the actual indictment?
I have not. I met with him yesterday to prepare for today's setting, but not for the arraignment. Yes.
Okay. Yeah, let's skip the arraignment, then we'll do that another time.
Okay. I can always file a waiver, Your Honor, once I visit him.
All right, we've already called the case, correct? No. Court will call cause number B 21-295 and 21-449, the state of Texas versus Nathan Durbage for purposes of a motion to reduce bond. What say the parties?
Defense ready.
Ball's in your court, counsel.
Yes, Your Honor. Jesus Vigil on behalf of Ms. McCollum, on behalf of Mr. Durbridge. So we did file motions for personal reconnaissance bonds or in the alternative bond reductions. I'd like to urge those motions as to each respective case. And the defense would like to call Nathan James Durbridge to the stand.
Mr. Durbridge, please raise your right hand. In the matter before the court, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. May proceed.
Can you please state your name for the record?
Nathan James Durbridge,
How old are you?
23.
Are you employed currently?
No.
Were you employed prior to being arrested?
Yes.
Where at?
Lowe's.
Will you still be employed at Lowe's once you get out of jail?
I don't know.
If you don't have employment at Lowe's anymore upon being released, if you were to be released, will you seek employment elsewhere?
Yes, sir.
Where did you reside prior to being arrested?
708 Smoky Mountain Drive, apartment 204.
Will you continue residing there upon being released from jail?
No, sir.
Where will you reside upon being released if you're released?
123 Summer Loop, Kerrville, Texas.
Whose residence is that?
Michael Durbridge,
And who's Michael Durbridge?
my dad.
Is that his residence?
Yes, sir.
Do you have a means of transportation?
Yes, sir.
What mode of transportation would that be?
2011 Ford Fusion.
Would you be able to attend court in the future whenever you are set for a court setting?
Yes, sir.
What are the two amounts your bond are set at?
20,000 and 30,000.
And how much is in your bank account?
About $400.
Do you have any family in the state of Texas?
Yes, sir.
How about any family in Kerrville?
Yes, sir.
Who exactly?
My dad.
What is the max you could come up with to bond out?
800 to 1,000.
Were you able to afford your own attorney?
Yeah. No, sir.
Do you have a court-appointed attorney?
Yes, sir.
Are you willing to be monitored, like GPS or monitoring something similar, if it means you could be released from jail as a condition upon your release? Are you willing to be subjected to that?
Yes, sir.
Did you go to school?
Yes, sir.
Up to what grade level?
12.
You got your diploma?
Yes, sir.
What high school?
Harlingen High School.
What brought you up to Kerrville?
My dad and to find work.
Will your father ensure to the court that you attend your court settings in the future?
Yes, sir.
How long have you been in custody?
About 3 months.
Do you understand that the court may impose a condition of your bond where you are not allowed to go near the alleged victim or the alleged victim's residence?
Yes, sir.
Defense passes the witness.
Mr. Rosenbaum,
May I proceed, Your Honor?
you may. Let me turn this.
Mr. Durbridge, is that how you pronounce your name?
Yes, sir.
Just follow along with me. I'm not asking about particular details about the cases. I just want to make sure that you're aware of what your charges are. Fair enough?
Yes, sir.
Okay. So in B-21-295, it's alleged that on March 25th of 2021, that you choked and or impeded the breath of Sarah Achilles. That's correct, right?
I understand.
And as a part of that charge, you were given bond conditions to be released from jail, correct?
I understand, yes.
Okay. And part of those bond conditions were assaultive offensive bond conditions, right?
Yes, sir.
And on those bond conditions, there's number one, you shall have no contact or communication, direct or indirect, with the complainant. That was number one, correct?
Yes, sir.
And then number five, you shall not possess or consume alcohol, liquor, narcotics, dangerous drugs, not prescribed to you or any other intoxicant. That was number five, correct?
Yes, sir.
And number 6 says you shall not violate any laws of the state of Texas. Correct?
Yes, sir.
And then number 8, it says you shall not go within 500 yards of the complainant's residence, the complainant's place of employment, or the complainant's school. Correct?
Yes, sir.
Now, you said you were living in apartment 204. What was that address again?
708 Smoky Mountain Drive.
And that's where Sarah Achilles lives, right?
Yeah.
Okay, so you were living there when after you were released on bond, correct?
Your Honor, I'm gonna object to this. I'm gonna object to this. This is going into statements that may incriminate my client, and it's a little beyond the scope of the hearing.
Well, this is about the bond conditions and where he was living. It's not about specific things about that, what happened afterwards, but where he
It
was
is
living.
asking him. It is asking about facts that may incriminate him, Your Honor. Stuff that's not pertaining to this case.
Need to rephrase your question.
Where were you living when you got out on bond?
What do you mean get out of bond? Because during March, I've never been arrested for that charge.
Okay. So let's move forward. Now you were also, you've been standing charged with, and this is again, just that you're aware of the case against you, not the specifics, but in B21449 on 6/1/21, correct?
Yes, sir.
And that is about 68 days between the first case and the second case, correct?
I believe so.
And that involves the same alleged victim, Sarah Achilles.
Yes, sir.
And in that indictment, it is alleged that you struck her in the head. It's alleged.
I understand.
Yes or no?
No.
Alleged that. But that's not the only charge you got from 6/1/21 on her about that date, right?
Yes, sir.
There's another charge, a misdemeanor allegation of driving while intoxicated,
Yes, sir.
and a DWI with open container.
Objection, Your Honor. I don't know how that's relevant. These are other offenses that have nothing to do with this case.
Again, I'm just asking if he's aware of what he's been charged with, and it's relevant because of his bond conditions on the case. That's just all I'm asking.
Why don't you clarify what date he was arrested on both of these cases when the bond conditions were applied?
Okay. What date were you arrested on both these cases?
I wasn't arrested for the first, the one assault one. I wasn't arrested for that one, but I was arrested for the continued family violence on June 1st.
Okay. But that's not the only charge, right? So that the record's clear.
That for June 1st, I got arrested for the continued family violence and then the misdemeanor charges.
Which are DWI,
Yes, sir.
DWI with an open container, correct?
Yes, sir.
And interference with an emergency phone call.
Yes, sir.
Okay, pass the witness.
I believe I touched up on it, Your Honor. I asked it indirect. So we're done with this witness, Your Honor. I do have one more witness.
May call your witness.
Yes, Your Honor. So the defense calls Michael Durbridge. He's here with me.
Mr. Durbridge, please raise your right hand. In the matter before the court, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you.
Can you please state your name for the record?
Michael Durovich,
How do you know my client, Nathan James Durbridge?
he's my son.
Where do you reside, Mr. Durbridge?
123 Summer Loop, Kerrville, Texas.
And if Nathan were to be released from custody, will he be staying with you at said residence?
Yes, sir.
Have you given him permission to stay there?
Yes, sir.
Will you ensure to the court that you will make your best efforts to make sure that Nathan attends the scheduled court settings in the future?
Yes, sir.
Defense passes the witness.
I have no questions for this gentleman.
Thank you, sir.
Thank you.
Additional witnesses?
That's all as far as witnesses from the defense, Your Honor. Just
Okay.
closing argument.
No witnesses from the state, just argument now.
Okay, you may proceed.
Yes, Your Honor. So my client's relatively young. He's only 23 years old. He's been in custody for going on almost 3 months. He can't afford to post a bond that's currently set, which is why we're asking for personal reconnaissance bonds, or in the alternative, significant bond reductions. My office, the public defender's office, does represent him, which demonstrates his indigence. He even testified he only has about more or less $400 in the bank account from what he calls. He's not a flight risk or someone that's going to run. He's got ties to the state of Texas and ties to the community, and his father, who he testified will make sure that he goes to his future court settings. They both will be residing at 123 Summer Loop here in Kerrville, Texas. Prior to being arrested, he was working. We don't know where that is at this point, but he did say he's going to seek employment. He went to high school, got a diploma, so he's got the bare minimum as far as skills and education to be seek employment. And there are places that are hiring here from what I've seen in my everyday drives. He has testified he's going to attend his future court settings. He has a means of transportation, so it's not like he's going to depend on somebody for a ride, or he's going to walk, or wait for the bus. He can drive himself to court. He even stated, I know the state mentioned some other offenses that are just allegations. Again, presumption of innocence still exists, so he's innocent until found guilty in the court of law. He's innocent on any allegations. If that's an issue with the state, though, he just testified he has no issues with the court imposing any conditions on his bond. So that settles that. The fact that he doesn't have the financial means to secure the current bond shouldn't be an illegal restraint on his, for him to remain in custody. He wants to resolve his cases, Your Honor. He wants to go to court. He wants to do it outside so he can come to our office and we could talk about the case. We're asking for personal reconnaissance bonds first, Your Honor, because he is indigent. We represent him. He's entitled to a reasonable bond, and because he's indigent, we represent him. We believe it should be personal reconnaissance bonds, given his age as well. In the alternative, we're seeking a significant bond reduction, Your Honor.
Your Honor, while he might not have been arrested and been given the bond conditions, he was aware of that incident, at least. That's what he testified to. And what the state's worried about is his behaviors seem to escalate, and, from having an allegation of choking strangulation to striking the alleged victim in the head, and all these other cases of DWI and misdemeanors. So we would have the bonds stay the same until we can resolve these cases.
Thank you. Mr. Advisor, the court's going to reduce your bond to $10,000 surety on each case and add two additional restrictions. Number one, you have absolutely no contact of any kind with the victim. You understand?
Yes, sir.
If you walk into a store and she's in that store, I expect you to leave. Do you understand?
Yes, sir.
Okay. The second requirement is that within 48 hours of release, you're going to have a GPS ankle monitor installed.
Yes, sir.
Can you comply with those conditions in addition to the others?
Yes, sir.
All right. We have any additional issues to address today?
No,
That is all, Your Honor, as far as the defense.
All right. Do we have a pretrial, or I guess he's set on next week's docket?
On the 30th.
Okay. We'll see you back on the 30th, sir. Thank you.
Thank you.
Thank you, Your Honor. May I be excused? Me and my witness?
Absolutely. Thank you.
Thank you, Your Honor. Have a good day.
Thank you. We have any additional defendants to address? Thank you all very much. All parties are excused.